All right, today we're going to dive into the really complex world of child visitation. This is where deeply personal family issues run smack into the very structured, very specific rules of the law. So let's open up the legal playbook and see how it works. This is really the question at the heart of it all, isn't it? When a family unit breaks apart, emotions are obviously running incredibly high, but the legal system has to step in and create some kind of clear framework. So how does it even begin to do that? Well, it all boils down to one single overarching principle.
And this is it. This is the North Star. Every single decision a judge makes is viewed through this one lens. There's a case, Ireland versus Ireland, that really spelled it out. The child's welfare is the paramount concern. Everything that follows is built on this foundation of making sure a kid has a stable, supportive home.
Okay, so we've got this foundation, the best interests of the child. So where does a court go from there? Well, it usually starts with a kind of default setting, a concept called reasonable visitation.
The law's default setting, and you see this in cases like In Re Marriage of Amos, is actually a really simple but powerful idea. It is good for a child to have a meaningful relationship with both parents. So the court's first goal, assuming both parents are fit and proper, is to make sure that relationship can happen.
But here's the thing. Reasonable is not some one-size-fits-all formula. Not at all. You can look at cases like Sinopol and Walls, and sure, you see these common patterns pop up, like every other weekend or a big chunk of summer vacation. But the absolutely crucial point, which a case called Pennington makes clear, is that there's no legally required minimum amount of time. It's always tailored to what works for that specific family.
But what if reasonable just isn't safe? What if there's a real problem? Well, to change the rules, to actually restrict or even deny a parent's access to their child, you can't just do that because you disagree with their lifestyle. The law sets an incredibly high bar.
And this right here, this is the legal test. It's often called the endangerment impairment standard. And listen, it's not about what one parent prefers or thinks is better. For a court to step in, it has to find clear, convincing evidence that the visitation would cause actual danger or real, tangible harm to the child.
So what does it actually take to meet that super high standard? Well, take a look at these examples. We're not talking about arguments over bedtime or too much screen time. The examples from these cases they're intense. We're talking about horrific physical abuse, serious substance abuse that makes a child terrified, or profound emotional manipulation. This is the kind of severe conduct that meets that high legal bar of endangerment.
Okay, and this is a really important distinction to understand. The court is not the morality police. A judge isn't there to weigh in on a parent's personal life choices. As the O'Connell v. Horton case puts it so bluntly, moral misconduct is not the issue. The only thing that matters is what's on the right side of this chart. Is the parent's specific behavior directly harming the child? That is the only question the court is there to answer.
And this brings up a super common scenario. What happens if a parent moves in with a new partner? Well, guess what? The rule is exactly the same. A court can't restrict visitation just because they don't like or disapprove of the new boyfriend or girlfriend. There has to be direct, solid evidence that this particular situation is having a direct negative impact on the child.
So, when that high endangerment standard is met, one of the most common tools a court will use is ordering supervised visitation. It's pretty much what it sounds like. Another adult has to be there during the parent's time with the child. It's a serious step, and it's also really important to know that when a judge orders it, they have to be very specific about the schedule. They can't just pass the buck and leave it up to the other parent to decide if and when the visits happen. Okay, so we've got the rules for setting things up and for when things go seriously wrong. But, life happens, right? Things change. And these court orders, they are not set in stone. They can, and very often do, get changed over time. And this right here is probably the single biggest reason why visitation orders get revisited. A parent wants to pack up and move away for a new job or a new relationship, and suddenly a schedule that worked perfectly is now completely impossible. So how does the law handle that?
Now, here's the key takeaway from modifying a plan, not restricting one. The standard is way lower. You don't have to prove that anyone is in danger. You just have to show that circumstances have changed in a major way, like a big move or a new school schedule, and that changing the plan would be in the best interest of the child. We're back to that same core principle.
So 204 miles, what's that about? Well, it comes from a case, Dover v. Dover, and it's a perfect real-world example.
A father moved 204 miles away, which turned the drive to pick up his child into a nearly 5-hour trek, each way. The court looked at that and said, yep, that's a big enough change to justify completely reworking the visitation schedule to something that's actually practical. It's the law adapting to reality.
Look, having a court order is one thing. It's a piece of paper. But what happens if one parent just ignores it? What if they just decide not to follow the rules? Well, the legal system has tools for that too.
And this is the main tool in the toolbox. It's called a family access motion. The best way to think about it comes from the Shooter versus Siebold case. This motion isn't about asking to change the rules of the game. It's about asking the referee, the judge, to blow the whistle and enforce the rules that are already in place.
And the process itself is pretty straightforward. Step 1, a parent isn't following the court-ordered plan. Step 2, the other parent files this motion. And Step 3, the court looks at the situation, and if it agrees that the order was violated without a good reason, it can step in and bring down some consequences.
So what can the judge actually do? Well, they've got a few options, and you can see them laid out in cases like Bielzak. The judge can order make-up time for any missed visits, force the non-compliant parent to go to counseling, hit them with a fine, or even make them post a financial bond to make sure they follow the rules in the future.
And get this, it's a really interesting little detail in the law, highlighted in cases like White versus White. A judge can absolutely order a family to go to therapy or counseling. What they can't do is delegate their power. They can't tell a therapist, you figure out the visitation schedule. The final say, that ultimate authority, always stays with the judge.
I wanted to share this quote from a case that's over 75 years old because it just perfectly captures the messy human truth that sits underneath so many of these legal fights. Even way back in 1947, the court saw it clearly. Two parents who loved their child, who were good people, but who just could not stop using that child to get at each other. It really shows you that while laws and procedures might change, the human drama stays very much the same.
And that really just leaves us with this final thought to chew on. The legal system, it provides a necessary playbook. It gives us rules for fairness, for safety, for enforcement. But the bigger question remains, can a court order, no matter how well written, ever truly heal the human conflict that's at the very heart of it all? That's definitely something to think about. Thanks for watching.